Recorded live. Welcome, everybody. This is Matthew, and you are tuned in to NTT, New Trust Technology, which is making payments under trust. NTT is merging titles and extinguishing debt. Welcome to the show. Before we start tonight, we'll go ahead and read our Notice Acknowledgement Agreement, and then I'll turn it over to Cristian. The document that we are reading is a practical treaty on the law of trust, and that is 1888, Volume 1 and 2 by Lewin. And as I mentioned earlier, page 753 is where we're starting tonight. This show or document is private and not to be construed or relied upon as being legal advice for an individual legal situation or employed for making legal decisions. You will not use this information for making a legal decision or for performing a legal procedure. It's not a substitute for legal advice and or guidance by a licensed attorney. This private show or documents are for academic informational purposes only, to be used at your own risk without liability to Cristian Walters. By accessing or reviewing this show and using the documents herein, you understand with agreement that with all rights reserved without prejudice, Cristian Walters is not an attorney licensed to practice law in the state of Florida or any other state, has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties, in preparation or use of the herein reference, and has no interest in any issue referenced therein, is not a party to this or any action arising from, and is only acting in an authorized capacity as liaison in communication between the parties. By reading and or using this information, you acknowledge and agree that you are not a client to Cristian Walters. These documents and show recordings are complete and void without this notice agreement being attached therein. By reference, in a breach of this agreement, upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Cristian Walters' discretion. Thank you for your understanding. And with that said, Cristian, you have the floor.
Okay, thank you, Matt.
You're welcome.
Like Matt said, we're on page 753 of Lewin's book, and that's Chapter 22, Trustees Under Settled Land Act, and we're picking up, I believe, at number 8. Cannot be assigned or released, number 8, on page 753. These powers of the tenant for life are not capable of assignment or release, and do not pass on a person as being, by operation of law or otherwise, an assignee of a tenant for life, and remainder exercisable by a tenant for life after and notwithstanding any assignment of his estate or interest. And a contract by the tenant for life not to exercise any of the powers is void. Okay, thanks, Matt.
You're welcome.
Okay, continue on. But the exercise of the powers will be without prejudice to the rights of the assignee for the value of the tenants for life, estate, or interest, and the assignee's rights are not to be effected without his consent, except that unless the assignee is in actual possession of the settled land or part thereof, his consent is not to be requisite for making of leases of the tenant for life at the best rent, without fine, and in other respects in conformity with the Act. Next section, provisions prohibiting exercise of power void. By Section 51, any provision in the settlement tending or intended to prohibit or prevent the tenant for life from exercising, or to induce him to abstain from exercising, or to put him into a position inconsistent with his exercising any power under the Act, is made void. And by Section 52, notwithstanding anything in a settlement, the exercise of a tenant for life of any power under the Act shall not occasion a forfeiture. Number 9, powers of Act cumulative. By Section 56, the powers conferred by the Act are not to affect prejudicially any powers subsisting under the settlement or by statute or otherwise exercisable by a tenant for life or by trustees, and the powers given by the Acts are cumulative, by which it is understood that the powers of the settlement and those under the Act are coexistent, and that it is optional with the tenant for life to exercise the powers conferred by the Act or his consent to the exercise of by the trustees of their powers being rendered necessary to subsection 2 to allow the powers under the settlement to be exercised. Number 10, powers of tenant for life absolute. but in exercising them, he is in position of a trustee. One of the objects of the Act, doubtless, was to give the tenant for life in his uncontrolled discretion large and absolute powers of dealing with and disposing of the settled land without requiring him to procure the consent of any person interested in remainder, or making him responsible for any one of the exercises of his discretion, subject only to this, that by Section 53, the tenant for life, in exercising any power under the Act, is to have regard to the interest of all parties entitled under the settlement, and is, in relation to the exercise thereof by him, to be deemed in position and to have the duties and liabilities of a trustee for those parties. In one case, Pearson J. even said, quote, "There is nothing in the Act to enable the court to restrain the tenant for life from selling, whether he desires to sell because he is in debt or wishes to increase his income, or whether without being in debt he thinks he can increase his income, or whether he desires to sell for more or for mere unwillingness to take the trouble involved in the management of the landed property, or whether he acts from worse motives as from mere caprice or whim, or because of his desirous of doing that which he knows would be very disagreeable to those who expect to succeed him at his death. There is not, so far as I can see, any power, whether in the court or in the trust or in trustees, to infer with his power of sale. But this seems to go too far and not to be due effect to the provisions of Section 53, under which the tenant for life is, in relation to the exercise of powers of the Act, made a trustee for all parties interested, and must, it is conceived, in the exercise of his discretion, be subject to the same rules as any other trustee, and be liable to the inferences of the court if exercise of discretion is affected by improper motives. And in the subsequent phase, in the same case, the remainder man, having offered to purchase the estate for £7,500 and undertaken at bar not to withdraw his offer, an injunction was granted by K.J. to restrain the tenant for life from selling for less than £7,500 and from entering into any contract otherwise than by public auction for the sale of the estate or any part thereof, for first communicating the offer to the remainder man and giving him 2 clear days to make an advance on the price offered. Next, effective decree and action to execute trust. It is conceived that the fact that the decree has been made in the pending action for the execution of the trust of a will or settlement of realty will not prevent the tenant for life thereunder from exercising the power of the Act without procuring the consent of the court. To require such consent would be to impose a fetter on a fee alienation by the tenant for life inconsistent with the spirit and terms of the Act. Number 11, notice to trustees. By Section 45, subsection 1, the tenant for life, when intending to make a sale, exchange, partition, lease, mortgage, or charge, is to give notice of his intention to each of the trustees of the settlement, and so to the solicitor for the trustees, if any such solicitor is known to the tenant for life, by registered letter posted not less than 1 month before the making by the tenant for life of the sale, exchange, partition, lease, mortgage, or charge, or of a contract for the name, and by subsection 2, at the date of the notice, given the number of trustees shall not be less than 2, unless a contrary intention is expressed in the settlement. Next, general notice sufficient. Under this section, it was held that the general notice of intention to sell or lease all of any part of the settled estate at any time or times as absolutely should incur was insufficient, but by Section 5 of the Settled Land Act, 1854, it is now provided by subsection 1 that the notice required by Section 45 of the Act of 1882 of intention to make a sale, exchange, partition, or lease may be notice of a general intention in that behalf, but by subsection 2, the tenant for life is, upon request by the trustees of the settlement, to furnish him such particulars and information as may be reasonable to require by him from time to time with reference to the sales, exchange, partitions, or leases effected or in progress or immediately intended, and the section applies by subsection 4 to a notice given before as well to a notice given after in the passing of the Act, provided by the subsection 5 that no objection to such notice was taken before the passing of the Act. Next section, except as a mortgage or charge. It has been observed that the Act of 1884 does not extend to the case of notice of intention to make a mortgage or charge, and such a notice, to be valid, must specify the particular mortgage or charge contemplated at a time when the notice is given. Next, Committee of Lunatic. The Committee of a lunatic tenant for life cannot give a legal notice under the Act unless he has previously obtained the sanction of the Court of Lunacy thereto. Next, Waiver of Notice. Any trustee, by writing under his hand, may waive notice either in any particular case or generally, and may accept less than 1 month's notice. And it is conceived that the waiver of notice or acceptance of shorter notice, if signed by all the trustees, will extend as well as the notice to be given to the trustee's solicitor under the Act of 1882 as to the notice to be given to the trustees themselves. Next, 12, where the notice is to sole trustee sufficient. Where the trustees are appointed by a settlement with such power as to make them under the Section 2 of the Act of 1882 trustees of the settlement for the purpose of the Act, and the powers are made by the settlement exercisable by the trustee or trustees for the time being, it will be sufficient to give notice under Section 45 to a sole surviving or continuing trustee, and the number of trustees need not, for the purpose of the notice, be completed. 13, purchaser need not inquire as to notice. By Section 45, subsection 3, a person dealing in good faith with the tenant for life is not concerned to inquiring respecting the giving of any notice required by that action. As, however, under the Act of 1882, at least a month's notice to the trustee was imperative, any person dealing with the tenant for life was bound to see that there had been, for at least that period, before any dealing took place, proper trustees to whom notice could have been given, but now under the Act of 1884, it will be sufficient if the trustees, although more recently appointed, by writing under their hands either waive notice altogether or accept shorter notice. It would seem to follow that the purchaser is not now and in any case bound to more than ascertain that there were trustees in existence at the time the contract was entered into. Next, notice by registered letter. If a shorter notice is accepted, it may still be sent by registered letter as provided by the Act of 1882. It is conceived that it is not essential to the validity of the notice that it should be sent by registered letter, but that it is only a convenient mode authorized by the Acts of the serving the notice. Number 14, duties of trustees on receipt of notice. We come now to consider what are the duties of the trustees of the settlement under the Act after it has been received a notice of the intended dealing by the tenant for life, and it is somewhat remarkable that, having regard to the importance attached to the Act to service on the trustees of notice of any intended dealing by the tenant for life with the settled land, the Act should be silent as to what the trustees on their part ought to do in interest of the remainder men when they receive a notice. No doubt if it comes to the knowledge that the tenant for life is contemplating or attempting to commit a fraud, as for instance by selling or leasing the property at a gross undervalue under some secret arrangement by which he is to derive a personal benefit, it would be their duty to come to the court and ask for an injunction to restrain the sale or lease. But if the dealing is not on the face of it fraudulent or improper, there is no obligation of the trustee to inquire into or take any steps in the matter. And in any case, there are, by Section 42, expressly protected from any liability for giving any consent or for not making, bringing, taking, or doing any such application, action, or proceeding or thing as to they might make, bring, take, or do. On the whole, it seems that the protection afforded to the remainder man against an improper exercise by the tenant for life is his powers by the appointment of trustees of the settlement, coupled with notice to them under Section 45, is of a very shadowy nature and in the majority of cases is of no practical value. Were consent of trustees necessary to exercise of powers? There are, however, some powers which the tenant for life can only put into force either with consent of the trustees or under the order of a court, and as to these, trustees before giving their consent must exercise their discretion on behalf of all persons interested. Next, sale of mansion house, timber. Thus, under Section 15, the principal mansion house on any settled land and the demise thereof, and other lands usually occupied therewith, cannot be sold or leased by the tenant for life without such consent or order. Under Section 35, a tenant for life impeachable for waste in respect of timber can be obtaining such consent or order, cut and sell timber ripe and fit for cutting. Next, improvements. So again, Section 25 enumerates the various improvements which fall under the description of the improvements authorized by the Act, but by the Section 26, subsection 1, where the tenant for life is desirous of that capital money arising under the Act shall be applied in or towards payments for an improvement authorized by the Acts, he may submit for approval of the trustees of the settlement or to the courts, as case may be required, a scheme for the execution of the improvements showing the purpose expenditure thereon. And by subsection 2, where the capital money had been expended is in the hands of the trustees, then after a scheme is approved by them, the trustees may apply that money in or towards payment for the whole or part of any work or operation comprised in the improvements on A certificate of land commissioners certifying that the work or operation or some specified part thereof has been properly executed, and what amount is properly payable by the trustees in respect thereof, which certificate is to be conclusive in favor of the trustees as an authority and discharge for any payment made by them in persistence thereof, or on B, a like certificate of competent engineer or able practical surveyor nominated by the trustees to approve and approved by the commissioners or by the court, which certificate shall be conclusive as aforesaid, or on C, an order of the court directing or authorizing the trustee to so apply a specific portion of the capital money. 16. Capital money under the Acts. We may here observe that under the terms capital money arising under the Act are comprised 1. Monies received upon any sale or enfranchisement or equality of exchange or partition. 2. Fines received on the grant or leases under any power conferred by the Act of 1882. And 3. The portion of rent under mining leases to be set aside under Section 11 of the Act of 1882. And 4. Money raised on mortgage of a settled land under Section 18 of the Act. And 5. 3/4 of the net proceeds of the sale of timber cut under the powers of Section 35, where the tenant for life is impeachable for waste in respect of timber. And 6. Money arising from a sale of heirlooms under Section 37 of the Act. Next, money arising from other sources. By Section 32, we're under an Act incorporating or applying wholly or in part the Lands Clause Consolidation Acts, or under the Settled Estates Act 1877, or under any other act, public, local, personal, or private. Money is at the commencement of the act in court, or is afterwards paid into the court, and is liable to be laid out in the purchase of land to be made subject to the settlement, then in addition to any mode of dealing therewith authorized by the Act under which the money is in the court, that the money may be invested or applied as capital money arising under the Settled Land Act. And by Section 33, where under a settlement, money is in the hands of the trustees, it is liable to be laid out in the purchase of the land to be made subject to the settlement. Then in addition to such powers of dealing therewith as trustees have independently of the Act, they may, at the option of the tenant for life, invest or apply the same as capital money arising under the Act. 17. Application of capital money. By Section 21, capital money arising under the Act, subject to payment of claims properly payable thereout, and to application thereof of any special authorized object for which the same was raised, is to be invested or applied in one or more of the following modes. Number 1, in investment of government securities or on other securities in which the trustee of the settlement are, by the settlement or by law, authorized to invest trust money of the settlement, or on the security of bonds, mortgages, or debentures, or in the purchase of a debenture stock of any railroad company in Great Britain or Ireland incorporated by the special act of Parliament, and having for 10 years next before the date of the investment paid a dividend on its ordinary stock or shares, with power to vary the investment into for any other such securities. And 2, in discharge of purchase or redemption of encumbrances affecting the inheritance of the settled land or other, while the whole estate is the subject of the settlement, or of land tax, rent charged in lieu of tithe, crown rent, chief rent, or quiet rent, charged on or payable out of the settled land. And 3, in payment for any improvement authorized by the Act. And 4, in payment for equality of exchange or petition of settled land act. And 5, in purchase of a signatory of any part of the settled land being freehold land, or in purchase of a fee simple of any part of the settled land being copyhold or customary land. And 6, in purchase of a reversion or freehold in fee of any part of the settled land being leasehold land held for years or life, or years determinable on life. And 7, in purchase of land in fee simple or copyhold or customary land, or of leasehold land held for 60 years or more unexpired at the time of purchase, subject or not to any exception or reservation, or in respect of mines or minerals therein, or of a respect of rights or powers relative to the working of mines or minerals therein, or in other land. 8, in purchase either in fee simple or for a term of 60 years or more of mines and minerals convenient to be held or worked with settled land, or any in easement, right, or privilege convenient to be held with the settled land or mining or other purposes. 9, in payment of any person becoming absolutely entitled or empowered to give an absolute discharge. 10, in payment of costs, charges, and expenses of or incidental to the exercise of any of the powers or the exceptions to any of the provisions of the Act. And finally, 11, in any other mode in which the money produced by the exercise of power of sale in the settlement is applicable thereunder. Next, improvements under Agricultural Holdings Act. And under the Agricultural Holdings Act in England, 1883, capital money arising under the Settled Lands Act, 1882, may be applied in payment of any monies expended and costs incurred by a landlord under the former act in execution of the improvements mentioned in the first or second parts of the schedule thereto, as for any improvement authorized by the Settled Land Act, and such money may be applied in discharge of any charge created on a holding under the Act in respect of any such improvement as aforesaid, and as in discharge of encumbrances authorized by the Settled Land Act to be discharged out of such capital money. 18, subject to direction of tenant for life. By Section 22, subsection 1, capital money arising under the Act is to be paid either to the trustees of the settlement or into court at the option of the tenant for life, and is to be invested or applied by the trustees or under the direction of the court as the case may be accordingly. Subsection 2, an investment or application by a trustee is to be made according to the directions of the tenant for life, and in default thereof according to the directions of the trustees, but in the last mentioned case subject to any consent required or direction given by the settlement with respect to the investment or other application by the trustees of the money or the trust money of the settlement, and any investment is to be in the names or under the control of the trustees. Subsection 3, the investment or other application under the direction of the court is to be made on the application of the tenant for life or of the trustees. Subsection 4, any investment or application is not during the life of a tenant for life to be altered without his consent. Subsection 5, capital money arising under the Act and the securities arising from the investment thereof are for all purposes of disposition, transmission, and devolution to be considered as land and to be held and go accordingly. Subsection 6, the income of securities is to be paid or applied as the income of the land and not disposed of would have been payable or applicable under the settlement. Subsection 7, the securities may be converted into money, which is to be capital money arising under the Act, and it will be observed that the tenant for life may direct in that manner consistent with the Act. The capital money is to be invested or applied, and the duty of the trustees in carrying out such directions is purely ministerial, and except where the consent or the approval of the trustee or trustees is expressly required as for an outlay or improvements, does not involve the exercise of any direction or any discretion, 19. Where settled real estate has been sold under the Lands Clause Consolidation Acts and the purchase money paid into court, the court will appoint trustees of the settlement for the purpose of the Settled Land Act and order the fund in court to be paid out to them to be held upon trust of the settlement. 20. Purchases confined to England. By Section 23, capital money arising under the Act from Settled Land Act in England is not to be applied in the purchase of land out of England unless the settlement expressly authorizes the same. 21. Form of conveyance. By Section 24, land acquired by purchase or in exchange or on petition is to be made subject to the settlement as follows. Freehold land is to be conveyed to the uses on the trust and subject to the powers and provisions subsisting with respect to the Settled Land Act, but not so as to increase or multiply charges or powers of charging. Copyhold, customary, or leasehold lands is to be conveyed to and invested in the trustees of the settlement on trust and subject to the powers and provisions corresponding with the uses, trust, powers, and provisions of the freehold land, but so as that the beneficial interest in land held by lease for years shall not invest absolutely in any person who is by settlement made by purchase tenant in tail or in tail male or in tail female and who dies under 21. 22. Application of money arising from limited interests. By Section 34, where capital money arising under the Act is purchase money paid in respect of leases or lease for years or life or for years determinable on life or in respect of any other estate or interest in lands less than a fee simple or in respect of a reversion, the trustees of the settlement of the court, as the case may be, may require the same to be laid out, invested, accumulated, and paid in such a manner as in the judgment of the trustees, or if the court, as the case may be, will give to the parties interested in any money the like benefits therefrom as they may lawfully have had from the lease, estate, interest, or reversion in respect whereof the money was paid, or as near thereto may be. Under this section, it will be duty of the trustee to take care upon a sale for the tenant for life of a leasehold interest or a reversion that the proceeds of the sale are so dealt with as not to affect the relative interest of the tenant for life and remainder man. This section corresponds with the 74th section of the Lands Clause Consolidation Act, 1845, and its construction will be regulated by the decisions under that act. Thus, if the property is subject to lease at rent, then the income produced by the investment of the purchase money, the tenant for life will be entitled during the remainder of the term for which the property was let to an equal sum only to the rent, and the residual of the income should be accumulated at compound interest until the end of the term, after which the tenant for life will be entitled to the whole of the income, including the income of the accumulations. So on the other hand, if the property sold was a lease for a short term, the tenant for life is entitled to receive an annuity of such an amount as will exhaust the proceeds of sale in the number of years which the lease had to run. 23. Heirlooms. By Section 37, subsection 1, where the personal chattels are settled on trust as to devolve with land until the tenant in tail by purchase is born or attains the age of 21 years, or so as otherwise to vest in some person becoming entitled to the estate of freehold of inheritance in the land, the tenant for life of the land may sell the chattels or any of them. And by subsection 2, the money arising by the sale of the capital money arising under the Act, which to be paid, invested, or applied, or otherwise dealt with in like manner in any respect by the Act directed with respect to other capital money arising under the Act, or may be invested in the purchase of the chattels of the same or any other nature, which to be settled and held on the same trust, and to devolve in the same manner as the chattels sold. But by subsection 3, no sale or purchase of chattels under the section is to be made without an order of the court. Next, whether proceeds of heirlooms devolve as personality. A dignity or a title of honor which descends to the heirs generally, or heirs of the body, is within the definition of the land, and heirlooms settled as to devolve from the dignity or the titles may be sold under this section. We have already referred to the sections regulating the application or disposition of capital money arising under the Act, and it is to be observed that under Section 22, subsection 5, capital money is, for all purposes of disposition, transmission, and devolution, to be considered as lands, and is to be held for and go to the same person successfully in the same manner and for and on the same estate's interest and trust as the lands wherefrom the money arises would, if not disposed of, had been held and gone under the settlement. It has been doubted whether the subsection has any application of money arising from the sale of personal chattels, and there seems no sound reason of making money arising from the chattels devolve as land, while if it is reinvested in other chattels, they are to devolve as personality. The latter part of the subsection points to money arising from land as being the subsection, or subject matter to which it relates, and would be construing the subsection in direct opposition to the spirit in which was framed to hold that while its apparent object was to leave the estates and the interests of the persons beneficially interested in land unaffected by the sale, when applied by reference to money arising from personal chattels, it is to have the effect of altering the nature of the estates, and in most of the cases of charging an absolute estate with remainder into a mere tenancy entail. To effectuate such change, the language of the Act should be clear and unambiguous, and it is conceived that the language of subsection 5 does not meet that test, and that the devolution of the monies arising from personal chattels will remain unaffected by the sale. 24. Receipts. By Section 40, the receipt and writing of a trustee of a settlement, or where the one trustee is empowered to act, of one trustee or of personal representatives or representatives of the last surviving or continuing trustees, for any money or securities paid or transferred to them or to him, is made by good discharge, and in the case of a mortgagee or other persons advancing money, exonerates him from being concerned to see that the money advanced is wanted for any purpose of the Act, or that no more than that is wanted is raised. In construing this section, Section 39, it must be borne in mind, which expressly prohibits the payments of capital money to fewer than two persons as trustees of the settlement, unless the settlement otherwise provides. And in taking two sections together, it seems to follow that in the absence of any special direction in the settlement, a sole personal representative of the last surviving or continuing trustee cannot give a good discharge for capital money under the Act. 25. Indemnity and reimbursement. Sections 41 and 43 supply the usual indemnity and reimbursement clauses for the trustees of the settlement. 26. Protection of trustees. By Section 42, the trustees of the settlement, or for any of them, are not liable for giving any consent or for not making, bringing, taking, or doing any such application, action, proceeding, or thing as they might make, bring, take, or do, and in the case of purchase of land, which capital money arising under the Act or an exchange, partition, or lease, are not liable for adopting any contract made by the tenant for life or bound to inquire as to the propriety of the purchase, exchange, partition, or lease, or answerable as any regards any price, consideration, or fine, and are not liable to see to or answerable for the investigation of the title or answerable for a conveyance of land if the conveyance purports to convey the land in the proper mode, or liable with respect to purchase money paid by them by direction of the tenant for life to any person joining in the conveyance as a conveying party, or as giving a receipt for the purchase money, or in any other character, or in any respect of any other money paid by them by direction of the tenant for life on purchase, exchange, partition, or lease. Under this section, the trustees are under no liability if they stand by or take no active part while the tenant for life is exercising his powers, but it is conceived that the indemnity given by this section to the trustee only holds so long as they have not actual notice that the tenant for life is acting fraudulently or giving improperly. At any rate, trustees who, with the knowledge of the tenant for life in committing a fraud upon his powers, take no active steps for the protection of the remainder men, relying on this section, would be acting most imprudently and would have little reason to complain if they were made personally liable for any loss arising from their negligence. Next, trustees see that conveyance is to be in the proper form. It will be observed that the trustees, in order to have the benefit of this section, where land is brought into the settlement upon a purchase, exchange, partition, or lease, must see that the conveyance purports to convey the land in the proper mode, but they are not bound to do more than take care that the deed on the face of it is properly drawn and is duly executed by the conveying parties, and that the person by whom the purchase money is paid by the direction of the tenant for life properly joins in the conveyance. 27. Differences between tenant for life and trustees. By Section 44, if any time a difference arises between the tenant for life and the trustees of the settlement respecting the exercise of any of the powers of the Act or respecting any matter relating thereto, the court may, on application of either party, give such directions respecting the matter in difference and respecting the cost of the application as the court thinks fit. 28. By Section 55, the powers conferred by the Acts are exercisable from time to time, and in exercising the powers, the tenant for life and trustees may respectively execute, make, and do all necessary and proper deeds, instruments, and things. There's a lot of good wording in this stuff for making out indentures here, so good source of material. Continuing on, number 29, additional powers. By Section 57, subsection 1, nothing in the Act is to preclude a settler from conferring on the tenant for life or the trustees of the settlement any powers additional to or larger than those conferred by the Act, but by subsection 2, any such additional or larger powers are to operate and be exercisable in a like manner and with all the like incidents, effects, and consequences as if they were conferred by the Act, unless a contrary intention is expressed in the settlement. 30. Tenant for life, an infant. By Section 60, where the tenant for life or a person having the powers of a tenant for life under the Act is an infant, or an infant would, if he were of full age, be a tenant for life, or have the power of the tenants for life, the powers under the Act may be exercised on his behalf by the trustees of this settlement. And if there are none, then by such person in such manner as the court, on the application of a testamentary or other guardian or next friend of the infant, either generally or in particular instance, orders. Under this section, the courts in Ireland refused, where an infant was entitled to an undivided share of the land, to appoint one of his co-owners to exercise on his behalf the powers of the Act, but required the appointment of an independent person. The court, in directing the mode of sale under the section, can order it to be made out of the court. 31. Tenant for life of a married woman. By Section 61, subsection 1, the foregoing provisions of the Act do not apply in the case of a married woman, but by subsection 2, a married woman entitled for her separate use or entitled under any statute for her separate property, or a femme sole, is without her husband to have the powers of the Act, and by this subsection. Subsection 3, where she was entitled otherwise than as aforesaid, she and her husband together are to have the powers. By subsection 4, the provisions of the Act referring to a tenant for life extend to a married woman entitled to a property as her separate estate or as a femme sole, and this brings the case of an infant married woman to entitled within Section 60, and her powers can, during infancy, be exercised by the trustees of settlement. But if the married woman is an infant married to a man of full age, and the property does not belong to her as her separate property or as femme sole, a question arises whether the powers of the Act can be exercised during her infancy. For in the case by subsection 4 of Section 61, the provisions of the Act referring to tenants for life extended to the married woman and her husband together, and as she and her husband together have the powers of a tenant for life, and the case does not seem to fall within Section 60, which applies only where the person having the power is an infant, the case appears to be a causus ominis from the Act. Number 32, trust or direction for sale. Where the settlement contains a trust or direction for the sale of property, the rights and powers of the trustees and tenant for life stand upon a different footing and are governed by the independent enactment contained in 63D, Section A. The construction of this section is somewhat obscure, and the extent to which the powers of trustees were affected by it was a question of grave difficulty. But by the Settled Land Act of 1884, the power given by 63D section of the Act of 1882 to tenants for life or other persons having limited interest are not to be exercised without the leave of the court, which leave is to be given by order naming the persons to exercise the powers, and until such order is made and registered as a less pendens. It seems clear to the trustees that the trustees may execute all trusts and powers reposed in them by the settlement as if the Settled Land Act has not been passed, while after an order has been made to the registered, and so long as it remains in force, the powers of the trustees are suspended, so far as it relates to any purpose for which leave is given by the order to exercise a power conferred by the Act of 1882. Under these circumstances, no conflict can now arise under Section 63 between the trustees of the tenant for life as to the exercise of the powers, and it seems unnecessary to consider what is the proper construction of the section in this respect. Number 33, where the powers of the Act are exercisable and any necessity arises for the trustees of the settlement for the purposes of the Act, they are by Section 63 defined to be the persons, if any, who are for the time being under the settlement trustees for sale of the settled land, or having power or of consent to, or approved of, or control over the sale, or if under the settlement there is no such trustee, then the persons, if any, for the time being, who are by the settlement declared to be trustees thereof for the purpose of the Act. 34, by subsection 2, Section 63, and the provisions of the Act referring to the tenant for life and to the settlement and to the settled land are to extend to cases under this section with certain exceptions, of which the following are the material ones for the present purpose. A. Capital money is not to be applied in the purchase of lands unless expressly authorized by the settlement of the capital of land or capital of money arising thereunder from the sale or other disposition of the settled land, but may, in addition to any other modes of application authorized by the Act, be applied to any mode in which the capital money arising under the settlement from any such sale or other disposition is applicable thereunder, subject to any consent required or direction given by the settlement with respect to the application of the trust money of the settlement. And B, capital money and the securities in which the same is invested shall not for any purpose of disposition, transmission, or devolution be considered as land unless the same would, if arising under the settlement from sale or disposition of the settled land, have been so considered and shall be held in trust for and shall go to the same person successfully in the same manner and for and on the same estates, interest, and trust as the same would have gone, and be held, if arising under the settlement, for the sale or disposition of the settled land, and the income of such capital money and securities shall be paid or applied accordingly. And C, land of whatever tenure acquired under the Act by the purchase or exchange or on petition shall be conveyed to and expressed in the trustees for the settlement on trust and subject to the powers and provisions which under the settlement or by reason of the exercise of any power of appointment or charging therein contained or subsisting with respect to the settled land or would be so subsisting if the same had not been sold or as near thereto as circumstances permit, but so as to increase by multiple charges or powers of charging. 35, commissions for sale. Where the settled property had been put up for sale by auction by the tenant for life under the Act, but withdrawn for want of a sufficient offer, and was afterwards sold by private contract on the same day, it was held that the trustees were at liberty to pay out the purchase money, one commission for conducting the sale, including conditions of sale, and so commissions for deducing the title and pursuing the completing the conveyance according to the scale of charges contained in the Schedule 1, Part 1, to be the general order under the Solicitors Remunerations Act, 1881, and also the cost occasioned by the concurrence of the sale for the tenant for life's mortgagees and a proper sum to the auctioneer for his charges. Next, Chapter 23, the powers of trustees. Powers of trustees are either general or special. General or special. Wow. Right there it is. The powers of trustees are general or special. The former, such as by construction of the law, are incident to the office of trustees virtue officii. The latter, such as are conferred v. terminatorium, that is, forget my Latin, that is, by the settlor himself, by an express provisio in the instrument creating the trust. Section 1, the power of general powers of trustee. Number 1, powers of trustees at law distinguished from powers in equity. I think we'll pick up there on page 774 and number 1 in section 1 at the beginning of chapter 23 next time. Good place to break off there. 774 next time, number 1. Powers of trustee at law distinguished from powers in equity.
Page 774. All right. Folks, if you got a question for Cristian, now's the time to jump in. Hit star 8 on your phone. It'll pop up on my screen, and I'll unmute you. First come, first serve. So you got a question, hit star 8.
If anybody has questions about the workshop or anything, feel free to ask. But if you wanted to attend or maybe request some more information, email me at movingtitles@hotmail.com. The email address, again, is movingtitles@hotmail.com. And put in the caption line, the subject line, NTT Workshop Registration Application, if that's what you're requesting. If you're requesting some additional information, just put additional information on the captioning. But if you want to join and pay, you have to register, and you have to request a registration application. So, again, send me an email at movingtitles.com, and in the subject line, NTT Registration Application.
Folks, if you got a question, hit star 8. So far, no takers here.
Everybody's still on vacation.
Yeah, they're. Oh, here we go. First caller in with questions. The user ID is HouseMart. You've been unmuted. Go ahead with your question. Are you there? Can you hear us?
Yes. Can you hear me?
Yes, we can. Welcome.
Now I'm unmuted. I was reading today in the Banker's Handbook, and it was based off an old call that you had done in December last year. And they were talking about how the trust is never expressed, so that's why they can basically, according to the subtitle of the book, create money out of thin air and force you into the debtor-creditor relationship. And I'm seeing now it's starting to come together how you can change some of that, but in that call you talked about changing the master documents and using the W8 bends some substitutions, and I was wondering if that's something that's going to be covered right away in the seminar, because I'm very interested in that.
You could probably ask that there. I don't know if we're going to talk about that. That's kind of something.
Isn't that the most fundamental thing?
No, not so much. It's more or less a more advanced thing. It's after you'd have the accounts all terminated that you'd want to be able to prove that you've gotten out and not to get back in. So they want to request a tax ID number or something, and you could tell them I don't have one, and I'm going to certify that I don't by giving them a W-8 Ben substitute.
Okay, so I guess I'm seeing it backwards then, and my wife tells me that's how I see the world. To me, if you don't attack those master documents, then everything else that you do could be easily reversed by some little piece of documentation somewhere that has nothing to do with what you've been working on, but forces the assumption that you've commingled your funds.
Yeah, because if you haven't corrected the master file, anything you've corrected outside of that would be like an individual issue. And then if anybody checked back to the master source, they would still see that you're still caught in the same situation, and then therefore you're under everything again.
So I put in my request for the application to that email address and did not get an application, but if I'm accepted into the seminar, that would be one of the things that I would like to at least in a breakout session perhaps talk about that.
Oh, that's possible, yeah.
Okay. That was all I had for tonight.
Okay, all right.
Thank you.
Anybody else with a question? Star 8 on your phone, folks. Thank you. Those are great questions, by the way. Got a question, hit star 8, and we'll unmute you and let you ask Cristian a question. Darren, you got a question tonight? I see you out here. Anybody else? So, Cristian, while we're waiting for somebody to hit star 8,
Darren, have a question?
no, he doesn't.
He doesn't have one? My gosh.
He has. I know.
Ate too much turkey and went to sleep. He's always got a question.
Yeah, he's always got great questions. He hasn't hit star 8, so I'm not
saying that's bad,
I'll hold off here. Maybe the council rests tonight.
Yeah.
You'd mentioned that you're going to do these sessions. Are they going to be 2 days a week? And you said, were they 2-hour sessions for the
yes,
course?
2-hour sessions, 2 days per week, Sunday and Thursday.
Okay. And these are web-based, I'm assuming?
Yeah, just like the calls we've been doing. There'll be a call-in number with the...
Beautiful. Well, we might have a short night tonight. If we don't have anybody else jump in. How smart? You have another question? Keeps popping back out here. I unmuted you again. Are you there?
Okay. This relates back to the course. Are these sessions going to be recorded so that we can go over them again later?
Yes. Uh-huh.
Okay. And I'm going right now, I'm looking at a transcription of the 1221 call, and you go into quite a bit on this W8 Ben and the alternative version of the W8 Ben as being the form to use, because the IRS's version would put you right back into debtor creditor. And it seems to me that without knowing how to alter the W8 Ben, we're just stuck with knowing that there is a way to alter it. So is that something that you covered?
Actually, the alterations that I mentioned were according to the IRS, because they even gave you the information. It's called a substitute W-8 bin, and they have a whole complete article on that. That was directly from them.
So they're telling you what to put into the alternate form. I noticed that they said some of the things, but that's sufficient to in the instructions for requester forms?
Yes, I think that's what it was called, requester forms, yeah.
Okay.
It spells out in there exactly what to take out of their form and what to leave in so that they'll recognize to accomplish what they...
Well, mostly they wanted the penalties of perjury in there. But
certification part.
And the certification. Okay.
And then just enough to identify who they're talking to, which is like part one, like the first, I think, 5 or 6 blocks. And then everything else in the middle is cut out.
Okay.
The last part, certification.
And then the other part of that had me concerned was by keeping the private and the public, I'm wondering, as an NRA, does that mean I have to give up my pension? Does that all of those benefits are gone, and I'm working off of non-negotiable debt instruments that I create through Treasury?
Yes, because if there's anything, if you terminate the straw man, then there's all the debt that's associated with it, including all the things, the benefits that they were giving you. They're all brought to zero.
And that's fine as long as I'm able to live somehow. I don't mind giving up the anchor. It feels like a lifeline until you recognize it as an anchor.
Yes, right. When you look at it, they've taken all your rights from you, all your assets, all your estates, and then given you back just a little bit, a pittance on what you really had. You did that conversion yourself on yourself. But yeah,
so that doesn't sound like the changing of the master agreements is all that complicated, and that's something that I should be able to ferret out from the IRS documents and the calls that you've already put out.
Yeah, but it does get quite involved because of everything we've been talking about. It's there's probably about 6 different areas that you have to simultaneously address and reverse them all.
Okay, so I'm going to continue, and by the way, your instructions to start from November of last year and move forward have been brilliant. I'm learning so much so fast, but I feel like I'm a year behind everyone else, so I'm trying to keep
Well, that's true.
Up.
The NTT's a year old now, but you can catch up, though.
Yeah, I will do it, and I'm very anxious to work with everyone on the seminar. So thanks for the opportunity.
Yeah, especially the high points, and you can get those on a list that we have from Faith to Trust. If you Skype her, she'll give you that list of. There's about 6 or 8 or 10 high points of the audio's specific dates. So, like we talked about withdrawal, redeposit, and repudiation, and different topics there.
Okay.
Guardian Ward.
Yeah, I've got her hit list, and I've gone through most of those, but I'm transcribing right from the beginning now, so that will be an archive for everyone else too. All right, I'll talk to you later.
All right.
Thank you.
Great, thank you.
All right. You got a question, folks? Hit star 8 on your phone, and I'll unmute you. You can ask Christian your question. If we don't have any callers that have questions, then you want to take it a different direction, Christian. Otherwise, we'll end the call early tonight.
Yeah, I think if nobody wants any questions, well, we'll just cut it short. And I think most people are out on holidays, so.
Still got a good showing tonight of callers here. Folks, here's your last chance here for a question. Thank you. If I said that right, you've been unmuted.
Hello, Christian.
Hi. Is Don?
Yes. How are you?
Good.
Hey, we're working on some of the paperwork for the response to the bankruptcy, the judge's order. He said something about he wanted the parties to come back with a show cause why the bankruptcy Chapter 13 couldn't be converted to a Chapter 7. Would it not be prudent for Doyle to file a motion or a petition in objection to the conversion based on the fact that it's been paid in trust and all of it should be a moot point?
Yeah, I think that's basically what he's asking you to do. He's really not saying, okay, we're going to take and switch this to Chapter 7 from 13 and just do a straight liquidation. I think he's using that as a mechanism for maybe you to come in and give reason why everything has not been already paid or extinguished.
Right.
In other words, it's an opportunity to come in with the bill in equity.
So instead of just writing a simple, I did work on the bill in equity today, but that was primarily geared toward the adversarial claim by the standing 13 trustee.
Mm-hmm.
We were kind of thinking maybe that we need to pursue that and get that brought forward, and maybe call for a hearing on that claim.
Yeah, because you got to get that declaratory relief hearing to prove the validity of the trust.
Right. Now, what we're going to do is I've written up the bill in equity best I can, based on the information we've gotten thus far, and then file it with a cover letter or cover sheet. I think it's called a cover sheet in federal court, like a summons, and pay the fee. So that will put us in, I'm assuming that will put us in the driver's seat in that particular case.
Yeah, that should bring the counterclaim or the bill in equity forward on top.
Okay.
So we've been working on like an outline. I've been adding some things to it as we go along. And number one, in that bill in equity, that is the counterclaim. And then I've got number A. Let me just get something here. A would be the proving the foundation for the trust. The 5 W's, the who, what, when, where, and why. And then B would be the elements of the trust. And then C would be the declaratory relief hearing to prove the validity of the trust. And make sure you don't put that as a declaratory judgment, but it's declaratory relief. And E, the bill of discovery for the proof of the rights and equity, and plead that as special matters. And also the subpoena for the discovery docs. Subpoena ducis tecum.
Mm-hmm.
In the subpoena. It's just like in Lewin, we're writing way back when we first started it, on the first page, I think it was, the subpoena was for the real man. So the real man is supposed to bring forth the documents for proving his rights, and if he doesn't, then you got him.
Well, now in the bankruptcy case, to whom would the subpoena be directed?
Well, whoever the trustee was.
Okay. That would be the Chapter 13 standing trustee.
Whoever it was, yeah, because that person would get a subpoena, and the subpoena ducis tecum. He would be subpoenaed along with the documents for the discovery.
How do you spell that, ducis tecum?
D-U-C-E-S, I think it's ducis tecum. T-E-C. UM.
That means bring everything with you?
What? I didn't hear you.
That means bring everything with you?
Well, the subpoena ducis tecum is documents. A subpoena is for the person. So subpoena ducis tecum is documents, and then subpoena is for the person.
Okay.
You can give just one, the subpoena, and then that's the person's going to show up, but you didn't tell them to show up with anything.
Right.
So use a subpoena ducis tecum to subpoena the man plus the documents that you want. And those are the bill for discovery documents. So then I've got F, the exhibits that you're asking for to be attached into your bill in equity got to be incorporated herein by reference, that particular phrase. And G, relief asked for, and that would be the performance. You got to have relief that you want. And H, an enjoining action of some kind to freeze the at-law side. And that would be like under Section 3790 of the Institutes of American Law by Bouvier, Volume 2. We talked about that last night, and it's almost like that as in equity that has to be granted. I mean, well, that was worded specifically that said, any time that somebody at law is coming at equity, the conscious of equity must grant an enjoining action on the at-law side and freeze the action until the equitable hearing can be heard.
Now, is that similar to the stay?
Yeah, stay. That's an enjoining action, yeah.
Now, we put the stay in that case and requested the at-law proceedings.
Yeah, but it might not have been proper the way you put it in because maybe there wasn't a bill of discovery first which gave you a reason why you needed a stay. Or declaratory relief was asked for, which would have been the reason why you needed to postpone their actions.
Mm-hmm. Okay.
But I think there might have been something deficient that the judge couldn't see because you didn't give good cause shown for any reason why he should give you a stay.
Yeah. So it would be your bill of discovery and the subpoena, all that stuff preceding it to give you the enjoining action for the stay.
I would say that you're trying to prove trust. You want a declaratory relief hearing, but you can't get the relief hearing on equity for, say, 30 days. In the meantime, in 10 days, you've got a hearing coming up on the at-law side. Well, that stands to reason that you apply to equity to stop the at-law side until the equitable hearing can be heard. Now, that should be granted according to equity. That's like a must, the way that was worded. It didn't say maybe. It said it must be granted. Check out Section 3790 of the Institutes of American Law by Bouvier, Volume 2. That's a free book off of Google.
Yeah, I already have that, so I'll pull that up.
I mean, that was a very interesting section. The wording in that said that at any phase of the action at law can be enjoined no matter what phase it's in, even after a judgment.
So that might be another thing to put into the foreclosure proceeding where it's already been adjudicated.
Yes, yeah, that's.
The more we read about that, the more we realize that was a railroad job and a kangaroo court.
Okay, then I had, I already mentioned the subpoena. That was J for the discovery of documents. And then K, protective order or sealing the case.
What was J again? I and J?
Yeah, I had K was the last one. J was the subpoena for the discovery documents. Subpoena or the subpoena ducis tecum.
Okay.
And K was the protective order or sealing the case.
And I?
Whoops, I missed one. I guess J should have been I. And K should have been J. Got ahead of myself there.
Okay, now I have up here E, the subpoena for the man, Chapter 13, Standing Trust Subpoena, Ducum, Ticum.
Yep.
Now, am I doing that right?
Yeah, that would be for the man to bring the docs.
And the subpoena in Section J, that's for a different subpoena?
Well, I was just kind of referencing a subpoena for discovery docs, but then that would really be the subpoena ducis tecum.
Oh, okay.
Just a straight subpoena is just for the man to come in, say for a deposition or something, and then or you're subpoenaing a person to get into a hearing. But a subpoena ducis tecum was for the man plus for him to bring something. And I want him to bring those documents into court.
Okay.
At that hearing. For declaratory relief or something like that. You could probably use it both ways.
Okay. Am I understanding correctly that this is all this would be one bill in equity with all of these elements?
Yeah, that's just in the bill in equity, the counterclaim.
Okay. So I'll have to rewrite it a little bit.
Floyd last night was talking about, you got there two kinds of bills in equity for main classification, which was the original, and then I forget what the other one was, non-original. So the original one is the first one. So if you put one in first already, then all the other bills would be the non-original.
Would you have to note it in the heading as non-original?
No, he said also something in there. He was reading that it didn't make any difference what you entitled it, as long as the proper information was in the body of the bill in equity. It didn't make any difference whether it was called something else. They were going to give you what you're asking for.
Right. Well,
but I like my titles, as to what's happening in the body.
Uh-huh.
Well, you could put on your first one, original bill in equity, and then if Floyd's on, maybe he'd come in and ask. I forget what the second classification was, the non-original. I think it was called something else, but so that would be every subsequent amendment and anything that you forgot, like say discovery, bill in discovery.
Include it.
Well, that would be a non-original bill.
So technically, you could do a original bill in discovery and then go back and do non-original and include these elements if you miss them, or if you want to do them individually.
Yeah, I don't think it's any difference what they're doing today on the at-law side anyway. It's like you've got original complaint, and then all the other motions are really, they're non-originals, and they're all called something. But the first one's called the original complaint, or the original pleading.
Okay.
Now, non-originals.
In the foundation of the trust with the who, what, where, when, and why, and how, would we want to include in this portion of the bill the reference to the court cases adjudicating trust issues? In other words, make reference to past closed cases.
You might want to, if you could come up with some pre-33 equity cases.
Well, I'm assuming that the ones that were shared on the Skype a couple weeks ago are 333. They were all equitable.
Some of them are, some are not.
Uh-huh. Do you think it's critical that they be pre-33?
It depends if you need SOIs in support of your claim, the NOI.
Uh-huh.
You might want to read the restatement on the law and trust, the second and the third.
Okay.
That's where the court's getting their information from.
Okay.
Like I was reading that last night, and what did I find out in there? Find it quick. Gosh, I forget where I was. I think it was section 13.
In volume 2?
I was in restatement for law and trust on the third, in section 13, I believe. I mean, even Gilbert's uses this also.
Huh?
It wasn't 13. Gosh, where was I? I don't remember. I had marked it, but I don't. They gave a short list of what they could use against you, and one of the things they could say, now what was it? I don't remember. In fact, I highlighted it. Oh, well, maybe we can talk and I can look and see if I can find it.
Yeah. Mine's on the computer. I have to call it up.
Well, here where we're just going by, it says, one of them was a section talking about the non-trust relationships. Now, this doesn't apply anything to you, but just where we're running by this. So, it says the term trust is sometimes used to encompass all fiduciary relationships. This restatement does not use the term in this broad sense. And this was in rebut to what I talked about last night on these guys using this executor letter thing.
Right.
And they're saying that any arrangement that has the effect of a trust is a trust, right out of the IRS Code 26, which is taken out of context, leaving some pertinent information out in between the commas, and taken out of context because it came out of the one about the trust, and number 2 is talking about the trustees. And you got to take the two of them together, and you're going to get a meaning. But anyway, it says the term trust is sometimes used to encompass a fiduciary relationship. But now this restatement does not use the term in this broad sense, given so many of the rules applicable to trustees are not applicable to other fiduciaries. So thus, an executor, I say it again, an executor, an executor, and an executor, thus an executor, guardian, agent, or corporate officer or director is a fiduciary. But the fiduciary duties and relationships involved differ in many ways from those of a trustee. I'll say that again. But the fiduciary duties and relationships of the executor involve different in many ways from those of a trustee. Not the same thing. Not according to trust law.
Mm-hmm. Does an executor also refer to someone who is executing the will of an estate of a deceased?
Yeah, that's another question. I mean, where's his death certificate?
Exactly. That's what I read about that in CJS. It said that the executor is the one who executates, or however you want to say that, executes the estate of a deceased person.
Right.
So if you're claiming you're the executor, don't you need to have that death certificate as well? Or
not only that, where's your power of appointment? Who appointed you?
Yeah, your POA. So it sounds to me like it's a
standing on midair, no foundation.
Exactly.
I don't know what's holding it up.
Yeah. I'm certainly not.
Everything we've been talking about on this show since day one has been backed up by facts that I've been giving everybody. And if you didn't go check out the facts that I'm telling you this stuff on, then shame on you.
Right.
And you just shouldn't take what I say for carte blanche and then go ahead and run with it, because I could be wrong maybe on some stuff. But I'm giving you the facts that I rely on, that I make my conclusions from, and you should go and check them out also and see if you agree with me.
Yep, exactly.
And many people are taking and running with this definition, saying, oh, this guy's quoting Title 26 IRS Code 2852, I think it was, definition of trust, but he's leaving out half of the stuff. He's omitting the pertinent information, which would change the meaning.
Yep.
There's parenthesis, it says, not including an estate.
Yep, that's some critical information.
Okay, here it is, I found. Section 5, talking about trust and other relationships. And it's listing from A through I, or A through L, excuse me. And it says the following are not trusts. And K lists relationships of debtors to creditors. They say that relationships to debtors to creditors, or debtor-creditor relationship, is not a trust. And that's probably what they're going to say. They're going to say, well, there's a debtor-creditor relationship here, and therefore it's not a trust. And they've got the documents to support that it's a debtor-creditor relationship on the at-law side, because everybody's signatures on these contracts, these debtor-creditor contracts. And then we're coming in saying that this is a trust. So now we've got to make sure that we rebut this debtor-creditor relationship by bringing forth the evidence that it is a trust. So that's going to be their defense. And that's probably what they're going to use against everybody.
So your rebuttal is that you've come to the age of majority and you realize that you've made a mistake and you're coming back to correct it, and now you've got the documents to prove that you expressed the trust?
Yeah, it comes back to intent. And when you discovered, when you first knew, because that's going to bring in another area of maybe latches, they're going to say, well, why'd you wait so long before saying, okay, this was that? Yeah, well, it comes back to intent again. And then on the evidence book that we're reading several weeks back a little bit there, where it says that the onus of probandi, or the burden of proof, shifts to the other party once the presumption is rebutted. And it said in there that you rebut the presumption by bringing forth evidence to support your side of the story, or your claim, which would be the elements and the records to prove the intent that a trust was the intent of the grantor, instead of this being a debtor-creditor relation.
Now, why are they refusing to acknowledge that evidence?
Well, Was that evidence in the pleading, or was it oral in court?
I think in the bankruptcy case it was both.
Okay, you could read it, what you had in your pleading directly onto the record, and that would also be oral, but I don't mean oral. It's like oral without it being in writing in the pleading. Because here's what I found out. It's like if you bring forth your evidence orally without it being in writing in the pleading, I found out that you have a higher standard to present the evidence by if it was not written in the pleading. Now, if it was written in the pleading, now you have the same level or height of evidence, and it's the same as in, say, civil or other cases or other matters. But if it's just strictly oral without it being in writing in the pleadings, you have a higher standard to approve.
In other words, you have a higher gate to get over.
Yes. So unless it's in your pleadings, you got a higher hurdle to jump over, and that could be a reason why. If somebody's coming in and saying, well, I've got a trust here, and they do that orally, and they don't have that in the pleading, they have a higher standard, and they'll probably judge it saying, I don't see a trust, because now you got a higher standard to bring it forth.
I know it's fun to be goofy, but this is the time.
I just lost him.
Who'd you lose?
But that's in the first, number 5th section of the restatement on the 3rd.
Okay. Go back and read that again.
Yeah, the first 10 or 13 sections would be a good thing to read.
Uh-huh.
All kinds of notes.
Mm-hmm. Well, we're going to...
Here's manifestation of intention. The phrase manifestation of intention in this restatement means the external expression of an intention as distinguished from an undisclosed intention.
Okay.
That was under E. And F is the elements of a trust. In the strict traditional sense, a trust involves 3 elements. Number 1, a trustee who holds the trust property and is subject to duties to deal with it for the benefit of one or more others. And 2, one or more beneficiaries to whom for those benefit the trustee owes the duties with respect to the trust property. And 3, trust property, which is held by the trustee for the beneficiaries. In a more comprehensive sense, the trust purpose is often included in discussion of these elements of trust, as in Part 3, specifically Chapter 6 of this restatement. So there's their 3 elements, they say. So although all of these elements are present in a complete trust, either or both of these elements, number 1 and number 2 above, may be temporarily absent without destroying the trust or preventing its creation. Then the next section is necessity of trustee. Then next one is necessity of beneficiary. Next section, necessity of trust property. Good stuff in there.
Well, does it talk about in the restatements of the laws on trust where the merger of titles?
Yeah,
that was one.
69 of the restatement 3rd, and it's probably in the 2nd also, but I don't know where.
Section 69?
Section 69, merger.
Well, that was one of the things that the attorney kept picking on is this concept of merger of titles and how that could become money and payment. Of course, he was coming from the at-law
Yes.
part of it.
Well, let's see. Definition of equitable asset in Black's 8. You might want to include that in there. Maybe it's under asset.
Yeah, I think he is.
Maybe it was the 4th.
It says an asset that is subject to payment only in a court of equity. Equitable asset.
Yeah, that was the short version. I think it came out of the 4th.
Now this is the 8th version here.
That one didn't quite, yeah, this is it. 4th and 4th revised, I think, are the same, so this is out of the 4th revised. Equitable assets are all assets which are chargeable with the payment of debts or legacies in equity and which do not fall under the description of legal assets. And that was making reference to Story's Equity Jurisprudence, Section 552, so we could look that up from there. Probably get a better one. Continuing on, those portions of the property which by the ordinary rules of law are exempt from debts, but which the testator has voluntarily charged as assets, or which being non-existent at law have been created in equity. And then it's listed in Adams Equity, Section 254. Check that out. And then it says, they are so called because they can be reached only by the aid and instrumentality of a court of equity, and because their distribution is governed by a different rule from which governs the distribution of legal assets.
So they're completely different characters.
Yeah. The only thing he says, he wants to know, well, how do I get paid here?
You've already been paid.
He's saying that, well, I want to get paid in apples, but, I got oranges over on this other side.
Oh, yeah, he's calling it monopoly money.
Monopoly money, yeah.
That's what he's calling it. Would he really be talking about the green stuff?
Well, you're not talking about money. He is. The legal title is nothing but commerce, which has a known value of monopoly money. Really, it's their money's monopoly money. You're the only one that has the real asset.
Yeah.
Which is not money. It's the real substance. And these guys are all 2 screws short of being total robots.
Yeah, exactly. You can tell that when you kind of throw them a curved ball.
Well, that's you can't even educate them someone anyway. The judge is the only one, and he's the only one that's going to listen to equitable merit.
But it appears as though there's some mechanisms that have to be tricked before you can get him to listen. And apparently we haven't tripped these triggers yet to get that to happen.
Yeah, I think declaratory relief is your biggest stumbling block, because once you got the court to declare that you have a valid trust, now the other side's got problems. Because the trust is going to involve the equity side with the equitable assets that you use to merge the titles and extinguish the debt. And I really believe that if you get into a declaratory relief hearing and get the trust declared to be valid, I think they're going to withdraw. They almost have to, because they don't have a case from that point on.
Uh-huh.
But your main goal is to do everything that you need to know how to do that's going to get that declaratory relief hearing scheduled, set up, and heard. And stop that at-law side with that Section 3790, that stay of the at-law remedy side, or relief side. Remedy side.
Now, the declaratory motion, we have to set that up ourselves, that hearing?
Yes. Yes.
Okay. Now, can that be just a simple motion to move the court to rule on the existence of the trust and declare the trust, or is it going to have to be a complicated bill in equity for the request for the declaratory?
Yeah, it could be a non-original bill if you hadn't put it in the original bill.
Mm-hmm.
An equitable, or let's put a bill in equity for declaratory relief.
Okay. Well, I shall work on this some more and incorporate these elements. And if we're successful tomorrow, we're going to try to make the recording of the last hearing, his judgment, and we'll Skype that to you so you can listen to it. Hopefully,
you get that other one transferred over to MP3 or something?
Yeah, we're going to try to do that tomorrow, and then we will Skype that to you and then let you listen to it. Hopefully, the sound quality will be good.
Here's 3790 out of that book, Institutes of American Law. It says, when a plaintiff, that be them, at law, is proceeding against equity and conscience, an injunction will be granted to restrain him from further pursuing his legal remedy. It doesn't say might, it says will be granted. And he may be enjoined at any stage of his action. If the application be made in time, the injunction will restrain him from going to trial. If after a verdict, it will stay the judgment. If after judgment, it will stay the execution. If an execution has been issued and the money has been made, the money will be stayed in the hands of the sheriff. Or, if after a part has been made any further proceeding will be enjoined. It doesn't make any difference what phase it's in on the at-law side. Equity will put a stop to any stage it's in.
Right.
And equity will grant it. Just got to ask for it.
Now, would you incorporate that into a bill in equity and put that into the case? For example, if you've got in his case, the foreclosure, the judge ruled on it. So go ahead and put this in.
Now, see, I would want to do some further work and find out where this Section 3790 came out of and check the footnotes and find out whether I could find some kind of equitable case citing to support this, which was pre-33, and include that in my request to support.
Okay.
It looks like the true equity, when you ask for it, it's automatically supposed to be granted. But when you go on to the statutory equivalent lookalike of the equity, the judge makes you perform according to the necessary elements that the statute and code equivalent says that you've got to have. And if you miss one, or if the judge doesn't feel like he wants to grant you it, then he doesn't have to. But it looks like this old equity stuff says it doesn't make any difference. There was no mention here about the elements necessary to prove your restraining order, your injunction. No, it just says if at law is attacking equity, equity will stop it wherever it stands.
Okay.
Well, anything else?
Well, I can't think of anything more. We've covered a lot of ground, so I will go over the notes and then try to incorporate this into my bill in equity, and perhaps I can call you back on Saturday and discuss any finer points if I should run into anything.
Okay.
I'll go back and read these sections that you just mentioned. Appreciate it, though.
Okay, Don, thanks for coming on.
Thanks, Don.
You're welcome.
Hey, Darren. Hey, Darren.
Hey, Christian, how are you?
Good.
Now, what, in regards to, let's say, for an example, you've been working, or there's been a court matter, and you send up your indenture, special orders, and can they repudiate as trustees, of course, by their words, even though their actions are showing different?
No, that's where that one case said, they could say one thing that they disclaim, but if they're acting as trustees, then...
Which case was that?
That was out of CJS. I forget exactly what section that was.
So, in other words, they can't...
455 or something like that, section 455 in the trust section, I believe. It was in the 400s, I know that. Because I made a big thing about it.
So, in other words, they can't repudiate their position.
No, not they're holding the trust res and, they haven't returned it. If they just turned the paperwork back in and didn't give it trust res, then hey, they're acting as trustees.
Okay. Well, let's just say it was a case, and basically it's just been an argument on the at-law side, where what they're trying to do, they're trying to make you pay a debt. And the thing is, the only trust res is that you're really that you would be doing is turning that case into an equitable title and telling him to extinguish the debt in the indenture, correct?
Yeah, they've already got the instructions to take the two titles, merge them, and extinguish the debt. Now, if he didn't do that, then that's not my problem. But trouble is, it's his problem, but he owes me the performance, the duty for that, and now he's in breach of that.
Yeah, that was a good call on Monday that Eric and those guys did. The only thing I could not keep my eyes open any longer. It was such a long call. So hopefully they'll have that on the audio soon to really go over that Monday night's call. That was really good. I would tell everybody to listen to that one.
So what we're talking about here is really under Section 7, which is establishment and enforcement of trust. And this
Section
is under
7 of
rights of City Key Trust against trustee. And in particular, Section 422, which is enforcing execution or performance of duties of trust.
And that's CJS?
CJS 422. It says that it may compel the execution of a power in trust, and similarly, relief will be afforded in equity against a trustee who attempts to hold the property and disclaim the trust.
Okay, so it's talking about trustee duties.
Yes, if you're holding trust property, if you've got the trust res, and you don't give it back, you are the trustee.
Right, and like I was saying, in a case like...
I had no problem if they want to disclaim. That's fine. Let them go ahead and disclaim, but give me the trust property back. Give me the original contracts. Give me the debtor-creditor contracts with my signature on them. I want them back.
Well, let's say hypothetical on, let's say, we're dealing with a state agency that's acting in behalf of another party. Let's say it's a child support case, okay? Mm-hmm. And all they're really doing is trying to enforce you to pay a debt where there's really no res per se. But what you're doing is actually you're making the case, the trust res, and...
I've already paid the debt, so to speak. I've merged the titles which paid the debt.
Correct. Yeah, and that was great on Monday's call, because what it did, it kind of kicked in a light bulb in my head where I think when I was trying to structure my indenture, my special orders, I kind of got, I think I went a little bit overboard, which a lot of times I do, but I've been learning. And I think...
Yeah, you spend too much time acknowledging the debt and not acknowledging the trust enough.
And what I really needed to go after more than anything was extinguish the debt. Really just go after the relief more than anything else.
Stress the fact that they never returned the res, therefore they're holding and making themselves liable under the trust as trustees.
Well, that's you see, the thing is I haven't sent them the indenture with the special orders yet because I just wanted to fine tune it to see if there was anything, because I didn't want to commingle, and I've had a discussion with a person or two on that, and I'm revamping it because I think I'm cutting everything back and just really going after to acknowledge the trust and extinguish the debt more than anything.
Because as soon as they bring up the issue that this is a debtor-creditor contract and that's the relation, no, I'm going to tell them, no, here's the relation, it's trust. And here's the proof.
Right. And that's on the merger of the titles.
Yes. Uh-huh.
But you have to be sure that your verbiage within the indenture and the special orders really stays on point in the acknowledgement of the trust, even though you do have to mention in those special orders to extinguish the debt, but your main focus is on the trust. There is a trust here. We have a special deposit. We have special orders, specially pleaded matter. But you still have to kind of use the verbiage. You have to extinguish the debt within that indenture.
Been extinguished, but he didn't ledger it.
Say that again. He didn't ledger it.
Yeah, the trustee was already given the two titles merged.
Right. And well, you see, my point is this. Before I ship anything off, once I put it in the mail, it's always easier to spend the extra time to be sure it's done right before you put it in the mail. Once you put it in the mail and then notice an error, and then you have to go through the amendment process, you know? And, I mean, I even do that, even myself, and I've had done that even when I've been on that at-law side, where I'll have people look over my paperwork saying, hey, did I miss anything? Did I leave anything out? Should I exclude something? And the reason is because once I mail it, I want to be sure that it's pretty airtight and that I'm not doing anything incorrectly where then it's going to take me more time to go back and amend it because I noticed an error because I didn't do it right the first time.
Yeah, if you really stop and boil it down to what we're in is we're in a relation battle, general versus special.
Right.
We're in a title argument between the relationship under the general title and the title under special.
Well, that's what I really liked. The light bulb that really went off in my head, and I think those guys really, Eric and those guys touched base on it. I think they really focused on the side that it's relief is really your main intent, is what you're going after, and it's not an action in revenge where you're just basically going after the relief more than anything else. Now, that doesn't mean that if there has been something done improper that you can't do that, but you do that once you've already established the trust in equity, and of course to be made whole, then you can go back to the ad loss side. But the thing is, it's best to do it where you already done it on the equity side, then you can revert back. Because you've really once you've slammed them on the equity side, you know, how are they really going to readdress it back on the at-law side once there's already been an acknowledgement of trust?
Yeah, I mean, it's already been merged. All the guy has to do is just ledger it as closed and bring the account to zero. That's all I want. That's the performance I want.
Right. So really, yeah, that's what Monday's call was really good, and that's really what cleared it, because I think the thing was I was trying to do too many things. I was trying to go after, but then also, too, I had to go back on my wording. I'm going, I shouldn't have that word general in there. I had to change it, go to special, and, change a few things. But I was seeing the points, and really was to cut it back to just acknowledge the trust, extinguish the debt.
Yeah, pretty much. I don't want to really mention the general is to say, hey, that general's a mistake. And I don't want to keep on harping on that. I want to say that, no, there's been a trust established, there's been a trust established, there's been a trust established, a trust established. So, but it's all the relation to the estate or the collateral being the survey, which is the witness, the identity, which that consists of the name, A, B, boundary, and C, whether it's public or private. And since in this case it's private. So the relation of the trust in the use of the res by the trustee in exchange for the beneficiary's fee, which is the performance or the duty. And that's my right to take the fee simple held in trust. And anybody else that has mistaken the res fee in repudiation of trustee's duty to the beneficiary is in trouble. They're in breach.
Right. Let me ask you another question. And this is something that I'm still not sure on the structure of it because it's not dealing with the debt, it's dealing with the performance. Now, hypothetically.
Right.
It is dealing with the right. And it's in regards to, I have these public employees, okay? They did some things that were unlawful. They got caught at it. I caught them doing it. I mean, even on the at-law side, they're dead. They're dead in the water. But
why didn't get them automatically then if they were dead in the water?
What's that?
How come the law didn't take care of them if they were dead in the water?
Well, there hasn't been an action filed yet. In other words, it's already been procured.
Yeah, but the only thing the at-law side can give you is damages for that, and then that's really the revenge.
Right. But if I defeat them in a breach of trust first.
Yes.
The at-law side would be so much. So let's say a hypothetical, okay? Let's just say I caught a bunch of cops doing some illegal investigations, okay? And it actually violated their oaths, their department policy, the whole 9 yards. How would I really structure that in like an indenture and special orders? That's where I'm a little confused at.
By coming at them under trust, I'm coming at them in a wholly different venue, and that's no pun. That's going to beat them up because I'm coming out of somewhere that they never recognize and can't see.
Right, but my question is how would I structure the indenture with special orders, because
as long as I stay in equity, I got the upper hand. But if I go on that at-law side, they got the upper hand.
Right, but I go into equity first, defeat them there. Now to be made whole, I can go back to revert back to that at-law side, but I still have upper hand because I've already defeated them in equity.
Right. Mm-hmm.
So my question again is how could I really structure the indenture and the special orders, because what would I really be converting the titles to? Would it be their oaths of office? Would it be the Florida Constitution?
No, I wouldn't use any of that stuff. I would just use a special, purely equitable trust that I would set up from something that my signature was on. I would get them in some kind of breach of some kind of pure equity trust.
See, that's what I'm trying to think, because there was nothing of my signatures involved, other than the fact that they breached a performance on their side.
Well, that's where you're going to have something to give them that you get them in the breach.
Yeah, and that's what I've been trying to kick around. How would I structure it? Because really, what an indenture and special orders is, it's really an agreement. It's a trust document that you have to create and be sure that it's structured properly, because really that's your nails in the coffin is that document.
Yeah, you're creating a confidential relationship, in other words, a trust, and that's the whole key.
Right. And that's where, because I'm not dealing with the debt, I'm not dealing with anything that I signed.
Well, it doesn't have necessarily a signature. It could be anything that you want, as long as it was delivered to them as trustee.
It would have to be a right of some type.
Well, the right derives out of that they have possession of the trust res. And whatever the duty was, it went with it.
Well, you see, their duties and performances that they have to stay within the guidelines as specified.
Your mind's still stuck in the outlaw stuff.
Yeah, it's because I'm trying to think of how I can structure it, and it keeps sucking me back over there because I'm thinking about, it's just like people talk about constitutional rights where they don't understand the Constitution is made for them, not for us. That's an instrument that is made to be held against them, not against us. And that's where I'm trying to figure out the structure to get them into that breach. And that's just the part I'm trying to kick around is how would I word it?
All I got to do is a blank piece of paper, put my name on it, and say, this is a special deposit this for the payment of the obligation of the debts, just like we talked about, making a special deposit.
Okay.
And send that to them. And then they don't take and apply that for the extinguishment. Now there's a breach of trust.
Okay. Even though there's no debt per se?
There's always debt. That whole world's made up of debt. That public realm is 100% debt.
Okay. You see, and that's really, maybe I'm just looking at it black and white. When
either forced because of the treaties.
Well, it's just looking at it. When I think of debt, I'm thinking of course, money on the public side.
Yeah, we got one actual tree in a forest, and you can't find it.
Yeah, and that's the part that I gotta kind of look at it in a different manner, because unless a debt means a different type of topic.
You got to set up a confidential trust relationship with them involving your signature.
Well, the only thing it would be on the driver's license, which they.
I don't have to have an offer for them to give them an offer, because that's what I'm doing. I'm canceling their offer to me and giving an offer back to them. It's exactly what they do to me in reverse. Except the offer that I've given to them is an order. I've changed it from an offer to an order. I've ordered them to make a special deposit, and that special deposit, my res, is the signature. And once they don't give that back, they're in deep doo-doo.
Okay, so if I say
makes a difference if there's a debt that exists associated with this or not. It's a trust relationship set up between you and the trustee to take care of any payments of obligations and debts, even if none exist.
Okay.
Still a relationship that's established in case any comes up in the future.
Right, so it would be the breach of a performance or duty on their part, which the res is what you're saying is basically the signature.
Yes. Now make your signature as a payment to apply it towards their debt.
Okay.
And when they don't pay their debt with your signature, because you got the right to do the trust any way you want to, if they don't do that, then they're in breach.
Yeah, because more than anything, it's on the performance side. Okay, I gotta think about it, because I get conflicting thoughts and I do get sucked back into that loss.
Making it too hard than what it actually is.
You're probably right. And that's from being brainwashed for a long time on that debtor-creditor side.
Yeah, you're trying to pick up a tool on their stage and dance to their tune using their stage and everything on their realm. I don't want to do that.
Well, not on the first stage. To be made whole, I could do it then.
Yeah, but I can be made whole just by getting a performance. And it's just like Solomon. He asked for, give me wisdom to take care of your people. And then since you didn't ask me for money, I'll give you the money. I'll give you the damages also.
Right. Okay. Yeah, I gotta think about that one. How I'm gonna do that. Yeah, okay, but Monday's call was real good. I liked that, and it really cleared it up where I think I needed to make it a lot more simple than what I have. And just really go the acknowledgement of the trust and go after the relief. And it's really just about that.
Yeah,
I think
I've mentioned that symbolically, that people have to empty the inside of the cup out and clean it first so they can fill it up with pure NTT or equity.
Right, and that's what you're...
From getting the right stuff in it is because you got all that other stuff in there.
Right, so really just clear it out, acknowledge the trust, the special relation, and basically extinguishment of the debt, close the case, or terminate the case is, the proper wording. And pretty much leave it at that. Just leave it at that, and this way, if they don't perform the way I want them to, now I got them on breach.
Yeah, now I got them in contempt.
Right.
In contempt, they'll end up spending time in jail.
Right, but the big thing is once you nail them on that, once you nail them on the breach, once you've got them on the breach, there's nowhere to go with that because on the equity side, they're automatically guilty. It's not like on the public side where it's innocent till proven guilty, which on the equity side, you're guilty till proven innocent.
Right, right.
So this way you hammer them there, you show that you go into the public side, you show the trust, or I'm sorry, you don't show the trust. You show the colorable titles that there's something being held in private. You get your special order, go into chambers, show that the trust is in existence and how they breached it. Then you have your injunctive order, and then you for your relief, and then shows that they're in breach.
Yeah,
Pretty simple.
The trick is how to come up with the colorable facts without revealing the private facts.
Right. Well, basically, that's what your UCCs are doing. You're creating a colorable title, which is your NOI.
Yeah, and having enough facts that they can say, okay, I see a trust now through this. Or at least get a hearing, just so you can bring in the private side stuff.
Right, because my statement saying that trust exists is my SOI, but my colorable titles are my NOI. So they have to acknowledge it because that did create a record, but then I got to move forth and say, well, I can't release the privity of my private trust unless it's done in chambers and chambers only.
Yeah, it's like in Doyle and Don's case, they're claiming trust, but yet they haven't had the hearing yet to get it adjudicated. Right. Until they get a hearing, set a hearing to get it adjudicated and bring in the facts, they're like stuck in limbo.
Why are they stuck?
Because there's nothing moving forward.
They probably didn't call the JA and ask for a hearing.
Yeah, that's the whole thing. Got to ask for a hearing.
You got to ask for a hearing. I tell people that all the time. They're going, I filed that motion. I haven't heard a thing. I go, did you order a hearing?
Right.
Was I supposed to order a hearing? What do you mean were you supposed to? They're not going to do it for you. People are crazy.
Yes.
Now the only time really at times where that sometimes is not relevant right off the beginning is in the federal courts, and I'm just speaking from the ad law side. Because a lot of times you're going back where you got an original complaint, you got a motion to dismiss, motion to strike, you going back and forth, and then what happens because you can't even get to the discovery stage yet of a case when it's in federal court until you have your pre-conference hearing. And a lot of times judge will say, okay, enough with the motions, let's just go to the pre-trial. Now you're into the discovery part, and that's where you can start requesting for your hearings to be heard, but a lot of time you're just shuffling your motions back and forth.
All right, now that's in federal. You have to have a pretrial?
Yes. You have to have a pretrial.
That could be good information for Don there because, actually he's in the federal, so.
Yeah, but bankruptcy might have its own rules, so he has to read his bankruptcy rules.
I know that's a catch. Yeah.
That's not really that, because it's kind of like it's like another kingdom. It's a kingdom on the federal side, but that could be XYZ kingdom versus ABC kingdom, like I'm talking about. So he has to read whatever the rules of bankruptcy are, and it'll clearly state in there. But I know myself is that I'm involved in a federal case right now, and we've been just basically going back and forth, and nothing's going to come to be until they get to the pre-conference hearing. Once that is it, which really what it is trying to save the court time and money and saying, does this really have to go to trial? If you guys can arbitrate, settle it, fine and dandy, we can close the case right now. But if there's no mediation or a meeting of the minds, then we move for trial. Now it opens up the discovery stage.
Okay, so as we were telling him that for the bill in discovery, he might not be able to do that just yet then.
That could be, right. But he has to check the bankruptcy rules. It might be different from the federal rules of civil procedure, because they might have...
I wonder if that may be the reason why the bankruptcy judge said something about going from 13 to 7.
Could be. I don't know. I don't know bankruptcy. That only applies to U.S. citizens.
Uh-huh.
Someone who's not a U.S. citizen can't go into bankruptcy. That's the whole case. But yes, normally a lot of times is that typically when you start a federal case, it's normally with a complaint, and just like even what they say on jurisdictionary, is that you'll file a complaint, you'll get a flurry of motions after that. They'll try to dismiss the case, but you keep striking them down. And then eventually it comes to the point where you're either petitioning for a summary judgment or a judgment on the pleadings, and the judge will basically come in and go, okay, let's go for a pretrial hearing, which will say, it's kind of like a mediation where you got to sit down with the other side saying, what do you want? And saying, here's what I want. Okay, you do this, and I want this or this, and it's a haggle session. And if you can agree to it, then this way it doesn't have to go to trial and waste the court's time and all the expense and everything else. Now you've come to a resolution. But once it gets to the discovery stage, now it opens up the whole can of worms. Now you can go for your interrogatories, your admissions, your petition for discovery, everything as such like that. Now, in my case that I have right now is that I'm suing a debt collector on a debt that never existed, and the thing is, they don't want it to get to the discovery stage, because then they're going to have to show where the account originated from, and it never did. There was no account. It was extortion, is what it was, and they're known for doing it. So the question is really going to be to them is how much do we got to pay you to go away?
Zero the count. Give me the performance.
Right. Well, that was when I wasn't very familiar with NTT back in August. Much more familiar with it now and understanding it. I just wish I had more time to study, because I think that's really the key in all this is you really got to understand it. And it's like learning a new language, but I think it's a much simpler language once you understand the structure, and really is you can't commingle it, because really what you're after is the relief on that side. But you still got to know what you're doing. I think the studying is the key, because you're the only one that can represent yourself in that case. No one else can do it for you. It's the same thing as even doing your indentures and your special orders. You got to know how to format it in such a proper way where your paperwork's going to be tight. Once you file it, you want your paperwork tight where there's no wiggle room. That's the key, because So that's my story, and I'm sticking to it.
Okay.
Okay, thanks, Christian. I appreciate it.
All right. Thanks, Darren.
Thanks, Darren. Great questions. Alrighty, what time is it here? 10:30. What do you say? We wrap it up for the thing.
That's fine. That's good with me.
Okay. Folks, thanks so much for joining us tonight. Did you have some closing comments, Christian?
Yeah, I might want to mention to Daryl and Don that it might be that the bankruptcy rules are not exactly what we're comporting this to, and there may be some catches in there, and you need to go back in those bankruptcy rules and see if you can find them. If you're asking for declaratory relief, or if we're asking for discovery, there might be some snags of a proper way to go about it under the bankruptcy that could be different from, say, the other state-level stuff. And there's only one way to do it, and that's go back in and check. Or ask some attorney that might be able to give you some information on it. But just like Darren said, it might be that you had to go to a pretrial first, and to get there, you got to be doing maybe something else prior to that. And then here we are asking for discovery, and the judge's going to say, well, I can't grant discovery. So I don't know. So that's all I had to say.
Outstanding. Folks, thanks again for joining us tonight. Christian, thank you again for your time and for fielding these questions. Plan on joining us again next Wednesday night at 8 p.m. Eastern Time for another session of NTT, New Trust Technology. Until then, everybody have a great evening. Thanks, Christian.
Thanks, Matt. You
Good night,
too.
everybody.